Our next case is Danhoff versus Fahim. Good morning. This is a 20-minute grant. You both will have 2 minutes. It's wrong on there. It's a 20-minute grant. You will both have 2 minutes of a free fire zone, and you may reserve time for rebuttal, but we ask that you keep track of that time.
Thank you.
And you may begin when you're ready.
Good morning, Your Honors. May it please the Court, my name is John Malone, and I rise before the Court today on behalf of the plaintiffs' appellates in this matter, the Danhoffs. I would like to reserve time for rebuttal if any is remaining. I feel it's important to frame the underlying case for this Court before we get into the issues specifically requested to be gotten into by the parties in the Court's order granting leave. And that is, this case is a medical malpractice case in which a plaintiff was required to demonstrate the standard of care through qualified admissible expert testimony, and a failure to do that in any medical malpractice case will result in summary disposition. This is a blending of an area of law, evidentiary admissibility, with the element of a medical malpractice case, the ability to prove the standard of care to the point where you could get in front of a jury, and some of the difficulties that inherently occur when you blend those two areas and the standards that are in place in regards to evidentiary questions and the abuse of discretion, and the resulting summary disposition that will always occur if a plaintiff is unable to get past that abuse of discretion standard and have their case dismissed if they cannot demonstrate the standard of care through admissible expert testimony. This Court in 1863 made a statement that I think is equally applicable today for the issue in front of the Court. It was in a different context, in the context of future damages. However, I think it's something that the Court should keep in mind when considering the issues in this case. And that is, the law does not require impossibilities and cannot, therefore, require a higher degree of certainty than the nature of the case admits. That was Allison Chandler in 1863. Here, the Court of Appeals concurrence acknowledged that the interpretation of Eller that the trial court and the Court of Appeals advanced in this case put the plaintiff in a legally impossible position. The law shouldn't allow impossible positions to have to be taken. It shouldn't require the parties to do impossible things. The trial court here was requiring that the plaintiff produce literature directly supportive of the expert standard of care opinions. There's a number of different problems with that, one of which being what constitutes directly supportive in any given context is broadly open to interpretation, and therefore increases the level of discretion being applied here beyond that which was really intended under the flexible inquiry initially elicited in Daubert.
Counsel, can you, so suppose we agree with you, and I don't know that even defendant is making this argument. We agree that there's no blanket rule requiring specific scientific literature to support an expert's opinion. So let's say we agree with you, and that's true when there's no literature on point, but isn't a reasonable way to understand Edry and Eller as saying actually that if there's literature on point that's been offered by defendant, that plaintiff must have something to address it. So instead of it being that there's no literature, which I understand that I think the trial court and Court of Appeals sort of characterize this case as saying that, but don't Edry and Eller really just sort of stand for the proposition that if there is literature offered by the defendant, the plaintiff has to have something to rebut it?
If those propositions were contained in Edry and Eller, they were unspoken. And so that's something that needs to be interpreted from those cases, and something that the Court of Appeals in this case and the trial court in this case did not interpret from those cases when it found that direct literature support was required.
Okay, and I think that I understand your point. I think that's a fair point, being that maybe Edry and Eller are fine, they're being misapplied, or they're being, for that point. Getting to the specifics of this case, didn't defendant offer some literature? So aren't we sort of in the Eller realm of defendant offered literature? If plaintiff can't offer something in response, he's not qualified.
So there are a couple of questions there, I think, Your Honor, and one of which would be, what's the literature being offered by the defendant? And it gets back to that question of, is it directly supportive of the defendant's position or indirectly supportive of the defendant's position? If there's peer-reviewed medical literature being offered by the defendant that says it's never a breach of the standard of care to do X, and the plaintiff's expert is saying it's a breach of the standard of care to do X, and they have no direct literature support or indirect literature support for their position, that's going to be a problem. However, if the defendant's coming forward with literature that indirectly supports their expert's position, why does that mean that a plaintiff needs to come forward with literature directly in support of their expert's position?
And so your contention is that the material, the literature offered by defendant, I think in reply to the motion for summary, is at best indirect literature supporting their standard of care.
And I would go further and say that in this case, plaintiff provided literature to the trial court which, at a minimum, was indirectly supportive of the opinions being offered by their standard of care expert. That should have, in and of itself, been sufficient for that testimony to be admissible.
Didn't the plaintiff's expert say he wasn't relying on those reports?
The plaintiff's
His
expert,
testimony?
the plaintiff's expert in his deposition testimony said that he reviewed those reports and
But
statistics.
didn't rely on them, and didn't bring them with him, right? Isn't that what he said?
Well, there's a question between what's the reliance on the reports when, if the plaintiff's expert is testifying in this case specifically that based on his review of the literature, this injury is incredibly unlikely to occur. Statistically, almost never happens. He's using that literature for the purpose of saying, when this procedure, which he's performed himself and knows how it's supposed to be performed, is performed throughout the country many times over, the literature says this injury doesn't occur.
Does that make it more likely that if the injury does occur, the fact that it's rare, that it's a violation of the standard of care?
Well, it may open the
Isn't
question
there a
as to
missing
how.
link? Yeah, isn't there a missing link in your expert's chain?
No, Your Honor, I don't believe so. Partially because the expert, the nature of any surgical malpractice case in particular, the expert will never have been present during the surgery to be able to opine as to exactly what happened to cause the injury.
That's not the point. The point is, just because something is rare, does that mean that when it occurs, there must be negligence?
No, Your Honor. However, if something is rare, in this case, again, the testimony was that this procedure, which the allegation was caused an injury to Ms. Danhoff's bowel, does not involve putting any instrumentation anywhere near the bowel. And so the plaintiff's expert coming forward and saying, I reviewed the literature, these injuries don't happen at all, statistically. It is incredibly rare if it happens at all. And on top of that, this procedure being appropriately performed, the way that he knows how to perform it and the way he knows others perform it, doesn't involve entering anywhere near the bowel with surgical instrumentation. Those two things together are an entirely reasonable basis for saying, in the event that this occurs, absent some other explanation for how an instrument impacted the bowel, it had to have been a breach of the standard of care.
Have you looked at the advisory note to the federal rule, talking about situations when there's not written documentary support?
And, Your Honor, I think that's a very important point here, and one which goes directly to the point being made in the Court of Appeals concurrence, which is that parties shouldn't be put in an impossible position.
Is that a yes or a no to my question? Have you looked at the federal advisory notes? Do we like those? I don't think anybody, maybe the trial court made a mistake, but I don't think on the appellate level anybody's saying here that you have to have, you never can just rely on an expert's experience and background. I mean, obviously you want to have support for the expert's opinion, but the federal rule talks about the situation where the expert's relying solely or primarily on experience, which I think is your situation here. And it says, then the witness has to explain how that experience leads to the conclusion reached, why that experience is a sufficient basis for the opinion, and how that experience is reliably applied to the facts.
And I think in this case, all of those elements are clearly met, in the sense that we
You
have an
agree that's an appropriate standard?
I think that the appropriate standard is a flexible one in which an expert's experience, especially in the context of medical malpractice standard of care opinions, is not discounted or swept away.
So the experts should be able to say it is so because I say it's so? That's your position?
No, Your Honor, they should be able to say, this is my opinion based on my experience, and then the
But
quality
doesn't the
and nature
federal
of their...
rule try to lay out then having him go through some steps and showing how that experience impacts the case? You're saying he shouldn't have to bother with that?
No, Your Honor, what we're advocating for, what the appellant is advocating for in this case, is not a change of any standard that's been in existence. The standard as initially articulated in Daubert for any evidentiary inquiry involving expert opinion testimony should be a flexible one. A trial court should go through a flexible inquiry, and if in a particular case that involves assessing an expert's experience and whether or not that expert's experience would in fact allow them to reliably opine on the subject matter, that is appropriate in a given case under a flexible inquiry that does not put parties in the impossible position of having
But
to
it has
produce...
to be something more than it's so because I say it so. You agree with that?
Well, yes, Your Honor, but I think there's a fundamental difference between an expert saying it's so because I say it's so, and it's so because I've performed a similar or same procedure hundreds of times. I've never had that experience before. I've had colleagues that have never had that experience before. In my training, I was trained that this doesn't happen if you do it correctly. That's all arguably based on the expert experience. We haven't talked about literature at all, but there are multiple bases being given for which that expert's opinion is likely highly reliable, and the trial court should, in fact, take account of all of that in determining whether or not the expert should be able to give their opinions to the jury.
I want to get to a point that was brought up at the last time this was here, and not the Cheetos reference, although that's a good one.
We're hoping you just keep coming back too. I'm going to try to think of
Yeah,
a version of-
yeah,
we'll
I mean-
grant again in this case, or at least supplemental briefing.
The point being
Keep this
is
going.
whether or not you requested a Daubert hearing. Are you, like, what relief are you requesting that, as a matter of fact and law, that this expert is qualified, or are you saying, I don't think I need a Daubert hearing, but if you disagree that, that there's a question that at a minimum I should have a Daubert hearing? Sort of a preservation of the Daubert hearing question.
Yes.
I mean,
While...
just to be clear, you took the position you didn't want a Daubert hearing at the trial court, and I don't think you've asked for one in the Court of Appeals or in any of your pleadings to us so far. Is that right?
The position that's being taken is the position that was taken here today, which is that the materials that were in front of the trial court were entirely sufficient to qualify Dr. Kobe's testimony as sufficiently reliable to go before the jury, and therefore a Daubert hearing was not necessary for the trial court to make that determination. However, whether or not to conduct a Daubert hearing is ultimately within the trial court's discretion. There may have been reasons for the trial court to order a Daubert hearing here, and if this court feels that a Daubert hearing would have been appropriate on remand, that's something that the court should include.
Is that a new position, or is that a position you stated before today?
I believe that that's a position that's been stated previously in the briefing, Your Honor.
Which brief?
Plaintiff appellant's brief on appeal.
Or is that just a inherent sort of alternative argument of saying, I don't think we even need to get to a Daubert hearing, I think I've submitted enough, but obviously if you're disagreeing that it's clear enough on the papers that a Daubert hearing is presumed to be the next step.
And that's the argument exactly, Your Honor, that I believe has been advanced in the briefing to date.
Okay.
You have 1:30 left.
Thank you. Looking at the specific questions asked by this court, whether the role of literature was accurately defined in Edry and Eller for the reasons that we've talked about, The answer is no, either on the face of the language in those opinions or as a result of the interpretations that have been used by trial courts and the Court of Appeals as evidenced in this case, where the outcome was impractical, illogical, the plaintiff was put in an impossible position. What would be the appropriate standard? A flexible inquiry, as initially dictated by Daubert and as often applied in other cases involving the weighing of expert opinion
Do you
testimony.
oppose the comment of the federal rule if we were to decide that's a good standard for these kinds of circumstances where experts relying solely or primarily on experience? Do you oppose that?
Do I oppose that, Your Honor? I suppose I misunderstand the question.
You know, generally, if we get involved in a case and we have to establish a legal standard, we're trying to think of what a good legal standard might be, because we have, you know, there's going to be lots of cases after your case involving this issue. And so I'm just wondering, since we're trying to, you know, if we're going to, I'm not sure there's a need to clarify the law, but if there was, that's a possible standard. So I'm just trying to get your input on it.
I think the good legal standard has already been articulated in Michigan, and that's whether or not a standard of care expert's opinion is sufficiently reliable should be based on whether or not that opinion is rationally derived from a valid scientific foundation, and that can be determined using any number of different factors applicable to a given case and should not be looked at solely
if
through
that's true,
literature.
the legal standard is clear, then you're just asking us for error correction?
Error correction in this case, and error correction to the degree that the Court of Appeals and trial courts are misapplying Edry and Eller. If this court feels that the language of Edry and Eller on its face is not problematic, which arguably it doesn't say that direct literature support is required, that argument could be made. However, that's what the Court of Appeals said was required in this case. That's what the trial court said was required in this case. So either the language is problematic or the interpretation of the language that's being
Didn't the
used
Court of
in
Appeals
courts
say
in
it
the
was
state.
generally required? I mean, I thought the Court of Appeals stated the correct standard.
The Court of Appeals said that the trial court considered literature, found it to not be directly supportive, and therefore it was appropriate that the trial court found that the testimony was not admissible.
Can I just follow up to Justice Viviano's? I get what you're saying. The rule is that it's a flexible approach, and it needs to include things such as literature in a proper case, background and experience. I think what Justice Viviano is asking is, do we need to provide some clarity, perhaps along the lines of the comment to the federal rule, about how to consider that background and experience prong or factor in Michigan's jurisprudence, right? Because I think you sort of agreed that it can't just be because the expert says it so, therefore background experience, and you're saying that that's not what's happening here. Do we need to provide the guidance of how to look at that?
I think guidance is certainly important and would assist the trial courts and Court of Appeals in the state. However, I think that it's also important to bear in mind that because this is a case-specific inquiry based specifically on the facts of each individual case, any guidance given must be couched in terms that it's general guidance. The trial court still must consider any relevant factor, and that a case-specific inquiry is what's required.
Thank you.
Thank you.
Good morning, I think. Yeah, it's still the morning. So I appreciate, my name is Scott Sauerbier. I'm responding on behalf of Dr. Fahim in this case, and also Michigan Head and Spine Institute. And I appreciate your giving me the opportunity to make some comments on the case. And I know that you all are very familiar with this case, and I do apologize if I've tried to make you all experts in doing an XLIF procedure. But I do think that it's important to understand that Dr. Fahim is operating through a paperclip-sized tunnel under fluoroscopy that tells him where he is at all times with his instruments. And it's also important that plaintiff's expert, Dr. Kobe, acknowledges that he's following the right method. He's following the right procedure. But then all of a sudden, after following the right procedure and getting right down to the spine, he leapfrogs over and says, well, he must have punctured with one of his instruments something that's 5 or 6 inches away. And so I really, as I'm listening to Justice Kavanaugh and Justice Viviano talking about really the method, and that's where I wanted to start here, is there are rules, and I agree with counsel that there are rules here governing the reliability of expert testimony all the time. And so in answer to the court's Hearst question as to whether the court's decisions in Edray and Elher correctly describe the role of supporting literature, the answer is yes. The short answer is yes, because it mirrors FRCP 702 and MRE 702, plus the Michigan Legislative Directive of 62955. And that offers a whole variety of points that are not exclusive. And further, it mimics going back to Daubert. And, I don't...
On the Daubert question, maybe I missed it, but I couldn't find in your briefing anywhere whether you believe the trial court should have held a Daubert hearing in this case.
No, I don't think it should. I believe strongly in 702 and the amendment that the federal courts just made on 702, which really didn't change the substance of 702, but it really, as I read it, encourages the trial courts to make these decisions themselves. Look at the situations, balance and weigh them. If you look at like the Kumho Tire case or GE versus Joyner, the PCB case, the justices or the trial courts looked at the facts very carefully in those cases, and they didn't have to go to the appellate court. And I think that's what our federal court is really talking about and urging the federal trial courts to do more of.
But Daubert didn't say that lack of literature knocks the expert out.
You're totally right, Justice Wells. So what I've always liked about Daubert, everybody talks about it, that's the standard all the time. But when you look at Daubert, there was no literature. And so in Daubert, this is the case of trying to decide whether Benedictine caused damage to a fetus. And when you look at that, the supporters of Benedictine had greater than 30 published studies and 130,000 patients that supported that Benedictine did not cause fetal malformations. The defendant had no literature. So how did the defendant prevail? And they did. So the defendant prevailed because they brought in 8 experts, certified experts, that were knowledgeable in the area, that had done chemistry type of studies regarding this, and they were allowed to testify. And so
So in this case, if plaintiff's expert, if they could just find 4 more people to verify this is super rare and it really shouldn't happen, is that enough?
Well, that could be. So when I go back to 2955, there's a whole litany of things. Does another expert in the field support your opinion? Do other experts in the field follow the same process or have the same opinion you do? So 2955 goes through subsections A through K, and then if it's a novel opinion, then there's a separate position to take. Well, then you still have to find people that support your novel opinion.
So I get the point that you're making that Daubert itself didn't have literature and it's not significant. How did we get from that to Edry and Eller, where they say that a lack of supporting literature is an important, it's not dispositive, but it's an important factor, or it does have some significance? And I guess, what do you make of amicus's argument that the reason how that sort of mistakenly, they contend, gets put into Edry and Eller, and then whatever happens afterwards of how courts are interpreting it, is because Edry relies on Craig, which was actually decided under Davis-Frye, right? And the general acceptance test, where obviously the existence or lack of literature may be in fact important, but Edry should have been decided under Daubert, and citing that. So where did, if literature isn't required, how did we get to Adrianella that seems to be placing, maybe not directly in their words, but how it's being applied, places an inordinate importance on the existence or absence of literature?
Just off topic, as you mentioned, Craig, you bring back my own PTSD because I tried that case. And where the plaintiff's expert came in without authority and said this child was brain damaged because of the pounding and grinding during delivery, and nobody supported that, except when you've got an infant in your arms in front of the jury. That's the danger of not really making sure somebody has an authoritative opinion. And I lost that case, and big time. And the hospital had many difficulties until finally the Supreme Court rectified that. But coming back to your question, I think that all of these cases from Daubert on say literature is important, but it's not the be end and all end of everything. And that's why our legislature, what was it, in 1996? I don't know, pretty close to that, enacted 2955. And that gives you A through K.
I mean,
and-
maybe
and
that's
talks
the
about-
case, but how do you get to cases like this, as an example, where the trial court and the Court of Appeals say that the lack of literature is controlling, in effect?
The court did not say that in this case. The court, first hearing, listened to things, and the Kobe had no support for his opinion that because you were doing an XLIF, that an instrument could perforate something else. And he
So
ignored
I'm
the
reading-
diverticulitis.
I'm reading directly from the trial court. It says, "Nothing was presented to the court that evidences Dr. Kobe relying on any published medical journals for his opinion, nor did he cite to any authority to support his conclusion that the procedure was performed incorrectly, resulting in the perforation." And then it goes on to say, while he did testify that he reviewed some publications, he failed to name those and did not present them at his deposition. The only foundation laid was his experience and background and his own opinion as to how he would have performed the surgery, which I think is arguable whether or not that's actually what took place during his deposition. But that's what the court said.
Well, I agree with you on that point, Justice Clement, but the court also said, referred to literature, but then kept begging, do you have anything else? Do you have anything else? And if you read the entire court's transcript, the court referred the plaintiff to, what about Edry? What about 2955? And encouraged them to look at these other, actually schooled the plaintiff to, you need to bring in something else. Suggested literature.
But doesn't that point that you're making, that the trial court begged them to come in with literature, sort of help establish the point that literature, the presence or absence of it, was dispositive to the trial court here?
I didn't think so. I thought the trial court was asking for anything, and suggesting that don't you have some literature? But is there anything, and when the court refers to 2955, if somebody reads that, it says literature is important, but it lists all these other things. So does the court, I mean, I don't think the court has to school an attorney like me in qualifying an expert. But the court did. And the court gave, and said, go back and read Daubert. And Daubert had no literature, as we talked about, but also talked about these are other ways that you can present your expert.
So what else could plaintiff have done here? We have a rare condition. There's no on-point academic study calling it malpractice, which not surprising given their medical journals, but we have a bunch of data showing how rare it is. I'm guessing rare conditions, there's probably not a lot of studies on them, so it's hard to find literature. What else could plaintiff do?
Well, in my brief, I set out under Roman numeral 3, 22 different points, bullet points, that the plaintiff could do to qualify an expert. And I'm not going to go back through those right now, but they're there. But 2955 talks about bringing in another knowledgeable expert practitioner who buys into the same theory you're talking about under these circumstances.
Why is that required? I mean, why?
Pardon me?
How many experts do you need to bring in that agree?
So it's the plaintiff's job to qualify their expert. And if their expert is being challenged, then they need to do something else. Now, for example, in this case, when I was going to, I don't know, the second court hearing or the trial court, I went out and I talked to 2 neurosurgeons. And I said, this is the theory. What do you think about that? Do you agree with that? And they said, no. And they both provided affidavits that said that he is not following reliable principles and methods in his opinion. I had an expert the other day on a key point. I said, well, how do you support that key point? Because there's a whole method behind it. He said, oh, it's my gut feeling.
So would it have been sufficient if plaintiff's counsel had gotten affidavits from other neurosurgeons saying, we think Dr. Kobe's opinion here is accurate? Would that have been enough?
I think you're right. I think that gives him the support. And, none of these cases, including Daubert, say that the expert has to come to the right conclusion, but they have to follow a methodology. They have to follow testimony has to be based on sufficient facts and data, and it's got to be a product of reliable principles and methods. And I think to me, that's what we're really talking about here. And has he applied these principles and methods to the facts? And so one of the facts in this case is from the pathologist who examined the bowel. So after the surgeon took out, 11 centimeters of bowel, and it was examined by the pathologist found that this diverticulitis had really infected this whole bowel area, and with, 10 or 11 different areas of diverticulitis that could rupture. And so Dr. Kobe doesn't follow the principles and the facts, and one of the facts is this diverticulitis in the area. And also, he never explains how you can get from this tissue tunnel that goes straight from the side down to, L3, L4, to be 5 inches away. This isn't just air down there. I mean, he's tunneling through tissue and fat. And so how does he support his opinion that a surgical instrument gets from the area of repair to perforate the intestine, which has fecal material in it, and then bring the instrument back to operate on the disc, which was successfully repaired and never infected? I mean, there are so many gaps.
Doesn't that go to whether or not his opinion is ultimately persuasive, but not whether or not he's qualified to give his opinion? I mean, we're here. You may be correct. He may be completely, unpersuasive to a jury that his theory is correct, of how this happened is correct. But we're looking at whether or not, and the trial court here said he can't give his opinion because there isn't sufficient literature to support his position. And what I'm struggling with of bringing in other people, you're saying Dr. Kobe isn't qualified because, there isn't enough to support his theory. But if you brought in 4 other physicians who have the same level or lack of literature or other things to support their opinion, that somehow that now makes his opinion supportable?
That's just what Daubert did. Exactly what Daubert did.
I mean, isn't that what the statute says too? I mean, if
Pardon me?
isn't that what the statute says too? You've been referring us to the statute.
But
I mean,
when you're-
isn't the idea that if he's making an assertion that basically it's like a res ipsa assertion, right? This is so rare that since it happened, it must be
Or strict
negligence.
liability.
Yeah. So then, but the statute walks you through the things that have to be considered, and if you don't have all the other things in the statute, surely bringing in other experts to tell you the degree to which the opinion and its basis are generally accepted within the relevant expert community, or whether the basis for the opinion is reliable, and whether experts in that field would rely on the same basis to reach the same type of opinion, surely that would be ways to substantiate your expert's opinion, right?
Yes.
But only if those other experts had literature to establish it?
No, nobody said that.
I mean, I guess that's what I'm saying. You're saying, wouldn't the same criticism of Dr. Kobe that you say you need other experts to support, wouldn't you be able to level that same criticism at doctors, other experts who come up with that same conclusion on
No.
the same basis of their experience and background?
Well, so Justice, I think that you're right in your thinking, but again, we're not trying to resolve the final issue. That gets them to some reliability that a judge can rely on. Okay, we've got this guy saying one thing. Okay, he's got another person or two or three, which meets 2955. So whether they're ultimately right or not, but they can get to the jury with some background of reliability. I would like to make one more point. I don't know where I am in my time. But I think,
Yeah, your time is up, so you have, make a very quick point.
can I
Very
make one
quick.
quick point?
Okay.
I think that this is very important because this decision will depend on criminal cases as to what an expert can say in, say, a bite rape case, or how it's going to affect criminal defendants. What some expert can come out of the blue and say. And it's going to be family cases, family law cases. It's just not a medical case. So thank you for your time.
Thank you. Thank you both. The case will be submitted.